Welcome to the Honourable and The Hack, a podcast about the stories that shape our province and our country.
Stewart McKelvey is one of Canada's 20 largest law firms, providing a full suite of legal services to clients nationally and internationally, with more than 260 lawyers specializing in core business needs and specialized areas of law. They support public and private sector clients operating across multiple and key industries and sectors, such as labor and employment, defense, technology, energy, and infrastructure.
Hello, everybody, and welcome to the Honourable and the Hack. My name is Andrew Parsons. Glad to have you here today. Very special show today. And as always, glad to be here with Alex Bill, my co-host, co-founder, and the main man.
Hey, Andrew. Good to be here. You know, spending as many hours as I do covering politics, working as a journalist, I often and easily forget that I'm a lawyer by trade. I often tease you about the same thing. So perhaps stepping back into old terrain for us today, but one I'm really looking forward to. Why don't you tell us about our guest?
So we have a gentleman here who can honestly say that he's the only person in the history of Newfoundland and Labrador to sit on the particular bench that he sits. Someone, again, born here in Newfoundland and Labrador, educated here and abroad, someone who has served in various levels of the court here in the province, and for the last just over 10 years now, about 10 years actually, he has been on the Supreme Court of Canada. Someone I was lucky enough to get to work with when I was in the department, always willing to give you advice or to just give you thoughts. I mean, always willing to share that massive intellect and, stories of being in politics many years ago, not as a politician, but as an executive, we'll say, as a clerk. Someone I've got a ton of respect for, and was amazing enough to grant us some of that time today.
And without any further ado, let's welcome to the show the Honourable Justice Malcolm Rowe.
Pleased to be here.
Good to see you, Justice. How are things in Ottawa?
Well, we're acting in the national interest, aren't we? As it is seen from Ottawa.
Yeah, we're excited to have you. It's not every day anybody in the media landscape gets to speak with a Supreme Court justice, let alone a little fledgling podcast in Newfoundland and Labrador. Both of us are very inexperienced lawyers, and so it's a little intimidating talking to one of the most experienced, but we really look forward to getting it into it with you. Andrew's frowning at me. He actually practiced a little bit longer than I did.
That's not a frown. Listen, I wouldn't say that at all. I remember the day that I actually hit. I was in politics longer than justice, and it was sort of a little bit of a sad day. But it's a good segue, Justice. It doesn't seem like it was that long ago that you were there getting sworn in, and now you're just about to hit the 10-year mark on the Supreme Court of Canada. I guess my first question, just to lead off, is how has it been?
It's been fascinating. That's the first thing. The workload is brutal, and it's absolutely unrelenting. One of the realities is that essentially I work 7 days a week, and I have worked 7 days a week pretty much the whole last 10 years. You know, when I go off on vacation, I'll probably work 2 or 3 hours a day, right? But,
Wow.
but it's just in order to fulfill the responsibilities properly, it just takes an enormous amount of time and effort. But it's rewarding. It's rewarding because you're serving the country. That's the way you have to look at it. You take on a responsibility. It's an honor to be called upon to serve. And if you feel like you're too tired or you need, to spend more time with your family, or you've just made your contribution, then you can leave. But while you're here, there's no let up. But it's always interesting.
Excellent.
Certainly, you don't give the impression that you're going to leave anytime soon, or strictly speaking, until they make you.
Yeah, and they're going to make me leave in about 2 years and 3 months when I hit 75. So the math is easy.
Again, going back to that, Justice, again, I'll talk a little bit about it after, but, coming from the courts in Newfoundland and Labrador and not have, being the first to represent our province on this national level, would you say that it's been everything that you've expected? Were there things that once you got there may have been surprising or, just sort of not what you expected? How has this, this last decade been in that sense?
I mean, I wasn't naive. I'd been a judge for, when I came here, about 17 years. I'd been on the Court of Appeal for almost 15 years. So I understood the appellate function, and I knew a couple of judges from this court, not terribly well, but I knew them well enough I could have a conversation with them. And I knew in a very broad sense the kind of task I'd be undertaking. But then when you're in it, it really hits you in a much more profound way. And it comes back to the idea of responsibility, because many of the decisions, every decision taken by a judge is important in the sense that the people who are before you might be the custody of a child, it might be a sentencing decision, it might be big contractual dispute that's very important for an enterprise, whatever. I mean, all of the decisions taken by judges, pretty much all of them, are important decisions. But what's different about this place is that you're not only deciding an issue between the parties, but you're setting legal rules and principles that govern the legal system for the whole country. And you're resolving from time to time, not always, but from time to time, issues of great consequence for the country. And so once you embark upon that, then you feel a sense of responsibility that you can view from a distance. But when you're doing it, it's just different. And that's what happens to you when you walk in the door and you begin to work here. You realize just the nature and the extent of the responsibility that you've signed up for.
Yeah, Justice, you talked about the relentlessness of the work. Does that sort of double sense of responsibility, not only to the parties involved in the litigation, which any justice probably feels, but that broader weight of your rulings, does that kind of weigh more heavily on you when it comes to that burden? Maybe burden isn't the right word, but the sort of weight and energy required to fulfill the job? Yes,
it does. I mean, particularly when I was a trial judge, I felt a great responsibility, right? When you're shaping the future of a family, or you have to decide whether someone's been convicted and then, impose sentence and the like. You're changing somebody's life. And that's a weighty responsibility. But again, I come back to the extent of the consequence. It relates to in some instances, not all the time, some things that are really important for the future of the country. And so I try to maintain a perspective, a historical perspective, and a perspective that encompasses the different parts of the country. Yes, I come from Newfoundland, and I never forget that. I mean, look over my shoulder, right? It's in my office, the Newfoundland, the old Newfoundland flag, the Dominion flag. But I have to be a judge who views my responsibility towards all Canadians, all variety of Canadians, new Canadians, Indigenous peoples, people in the north, people in the west, of course, people in the Atlantic provinces and Newfoundland. And because the consequences are so profound of our decisions, I want to be mindful of what's really engaged. And so my knowledge of Canadian history and Canadian geography and contemporary Canadian life is pretty good. I mean, I've traveled a great deal in the country. I don't travel as much as I used to, although I still do, give lectures and the like, mainly at law schools. But I try to put the resolution of the issues before us in that broader historical and contemporary context of Canada and its many components, which you tend not to do when the issue is quite specific between the parties, right? So that's part of the burden is keeping in mind, the impact on the country.
Yeah, thanks for that. That concept of consequences touches on something I had saved for later in this podcast, and I'll ask my co-host indulgence as 2 quick questions about it, brother. Because you are known to be one of the more prolific writers of dissents. And I was trying to do a little tally before we came on here. Quite a few of those are cases in which you were the sole dissenter. And, the Churchill Falls case, I'm sure people in this province would remember. But Taylor, you had a solo dissent just this week. Several of the criminal cases that you've been you've ruled on, you were a solo dissenter. Stevenson, Soon, DePaula. Do you have the record amongst your peers for solo dissents, or is that perhaps your colleague Justice Cote?
Oh, Suzanne Cote she's like I don't know, the Wayne Gretzky of dissents. Right? I mean, I don't know where I am. The Davy Keon, maybe, or something. If you're old enough to remember Davy Keon. No, but I mean, you have to think about it before you write separately, either in dissent or sometimes people put some of my reasons for decision in the category of dissent, whereas they're not. They're actually separate reasons concurring in the result. So I agree in terms of the resolution as between the parties, but the legal framework in which the analysis occurs is one where I disagree with my colleagues, some aspect of the legal framework, which brings in something which is quite significant about this court, because I would say that the effort that goes into hearing and deciding cases, probably no more than 20%, roughly, of the effort goes into deciding which party wins in the particular issue which is before the court, the particular dispute. The 80% of the effort, roughly, goes into a general statement of the law which accompanies and lays the groundwork for the particular resolution of the particular dispute between the parties. And this is very different from the courts of appeal, because, people have a sense of, okay, what a trial is. I understand that pretty well. Appeals, people have a less clear view of that. You would know, both of you as lawyers, what really happens is if one of the counsel says, I think there was an error made at trial, and we're going to go to the Court of Appeal and see if we can have that error corrected. That's fine. That's what the courts of appeal do. Error correction. Is there an error and should it be corrected? And this court, in a sense, we hear appeals from the courts of appeal, but we don't do the same thing they do, or at least not quite the same thing they do. We have to resolve the issue between the two parties, but in effect, we use the particular dispute as a vehicle to make a general statement of the law which is disclosed by the dispute. And so in the Court of Appeal, I wrote reasons which were very often 12 to 15 pages long. And that was all I needed to say. And whereas here, it would be uncommon to prepare a set of reasons less than, say, 40 pages. And it wouldn't be uncommon to write 50 or 60. And that's because what this court does beyond resolving the particular dispute is to examine in a very thorough, almost comprehensive way, a legal issue, and to make a definitive statement of law, which is then binding on everybody in the country. That's what comes from being the Supreme Court. And then take that general statement of law and apply it to the particular circumstances of the case to get a resolution. But most of the time is not spent in figuring out which of the two parties wins. It's figuring out what we should say as to the general statement of law, which then binds the whole legal system in the country. You know.
So for any common law system, a dissent is often used down the road, as argument to overturn or change law. And that's beyond basic for you. I'm saying it for the benefit of our audience. When I was in school, Rodriguez was a split decision on medically assisted suicide. A few years after I graduated, that dissent was relied upon amongst other things in a case that overturned Rodriguez, and the law of this country changed. When you are considering, am I the only one going against all of my colleagues here on a decision? Is that weighing on you that I have something to say and that might change the law 10, 20, 100 years from now? Or are you just kind of going where your analysis takes you?
My responsibility is not to go along. My responsibility is to render a decision according to my analysis and, I suppose, my conscience, but maybe legal analysis. And you don't dissent, and you don't write separately for inconsequential reasons. I mean, you shouldn't do that. But if there's a matter of real consequence, something of considerable substance, for me to sort of say, well, I'll just go along, I don't think I'm doing my job. And so on a number of occasions, I have formed a different view of how the legal principles should be framed, how they should operate. And that's I end up writing separately in dissent or separate reason concurring the result. And it isn't about saying, well, if I write this out and I'm very clear and maybe someone will pick it up and I'll win in the end. Like I'll win and they'll lose. Forget that. You get that in your head, it screws you up. But what you want to do is fulfill your responsibility, which is render a decision according to your best analysis, but also, which isn't quite the same thing, but does pick up on your point, you contribute to the body of law, even if it isn't dissent. It's in the Supreme Court reports, and there is a perspective there and an analytical framework that is available and that has a certain standing and that can be drawn upon. And over time, it can become influential, or it may just be lost in the mists of time, and that's how it is. But it's a contribution to the jurisprudence, and I try to contribute to the jurisprudence as best I can, and some of the seeds will fall on fertile ground and some will not. But that's for somebody else to sort out.
So, Justice, I want to go back. I'm always interested in, how people got to where they are. You've been sitting here now, with an amazing judicial career on, all these different levels. But going back in time, being from Newfoundland and Labrador, being from St. John's, I think mom and dad were from near Fogo, I believe. What brought you to the law? Did you know early on? Is this something that when you were going to high school, then into university, like what got you interested in the law? I'm making an assumption here. I'm not like, how did you get there? I don't believe your mom and dad were involved in the practice of law.
No, no, no. My father started out as a fisherman, but after the war, after the Second World War, he was born in 1912. So he was in his, mid-30s by the time he moved to St. John's. And he worked in a warehouse. That's what he did. And my mother worked first in the sanatorium, when there were a lot of people with tuberculosis. Then she took a little time off when my brother and I were very young. And then she went back to work in an old age home where she helped out until she retired. So it was, we had enough money. We didn't have any extra, that's for sure. I did very well in school. And so it sort of, maybe I can make a professional career. And I also can't drive a nail straight. So I figured, as my father said, it was better if I got inside work, right? And so, I thought about seeking to become a physician, and I almost did, actually. I almost went to medical school. I was very interested in political science. I thought about that. But in the end, I kind of gravitated towards the law because I was interested in what might be called how the society was organized, in particular the institutions of the state. And so public law, as opposed to private law, has always been an interest of mine. And so what I find, which is kind of interesting, is some of the issues that I'm called upon to deal with relating to things like what's the role of the legislature, what's the role of the executive, what's the role of the courts, and the like. I have been thinking about these issues in a structured way for like half a century, longer, really, if I look back to my childhood. And it's been an abiding interest. And I've been just enormously fortunate that throughout my career, which has taken a whole variety of changes, it has tended to be about the operation of government and the institutions of the state and how the law structures these things. Even though, of course, I had private clients, and at one point when I was practicing law, and of course, when you're a trial judge, you deal with a whole variety of things, like who gets the kids at Christmas, and where's the fence supposed to be between these two properties. But the unifying idea has been, how the society is governed and the role of law in the governance of the society. Yeah.
So that's a good. I'm going to continue on that vein, Justice. You mentioned poli sci, really enjoying that, and that's something that you did do as well. A lot of people may not know that, but I mean, you've had some experience in the federal government as well as in the provincial government, while helping to run the public service. Having been, I think, was the clerk at Executive Council back, not that long ago. Maybe if you could talk a little bit about that. I'm assuming that was enjoyable. I mean, you knew you were probably going to end up back in the law, but those roles are, extremely important.
Yeah. Well, when I left law school, because I studied in Toronto, because of course there's no law school in Newfoundland, and when I went home, I pretty much my first job was as an officer in the legislature. I was the clerk assistant. I was the procedural advisor to the speaker, and I was sort of the clerk of committees. And it was really quite valuable to me. It was early on in my career. It wasn't for a long time. It was only for a little over a year. But it did give me a sense of the operation of the legislature as opposed to the government. And Andrew, as a parliamentarian as well as a minister, they're not the same. Right?
Yes.
The legislature is a different world, and so I gained that degree of insight from my exposure and participation in it. Then I went off and just almost by happenstance, I ended up joining the diplomatic service, which wasn't easy to get into, but somehow I managed it. And so I went, I had two postings, as they call it, in the diplomatic service. One was to temporary duty for about 6 months to the United Nations General Assembly. And when you hear people talking about the United Nations and the General Assembly and everything else, most of the time you get it completely wrong. It's not like people think it is. And being there and participating in it, again, gave me an insight in the way that, serving with the legislature did. And then I sort of said, well, I think I'll just go back to being a lawyer. And so I went into private practice here in Ottawa for, family reasons, really. My wife was in the federal public service, and she had an enormously successful career here and now in the United Kingdom. And so I thought I'd left government behind, but I was completely wrong, because while I was in a private law firm, most of the work which I did was for government. I was called in as a sort of a lawyer/consultant on legal issues, public policy issues. And when I'd finished one file, I said, well, that's that. I'll never be called on again. I was called in again for another one. And what it meant was that I dealt with ministers and deputy ministers being the most senior officials in the public service, really quite extensively for most of my time in private practice in Ottawa, and found myself on any number of occasions dealing with international legal issues as well, and spending a fair amount of time down at the United Nations in New York and in Geneva, again in a sort of an advisory capacity. And at least one occasion assisting at the International Court of Justice in The Hague. I don't want to exaggerate that. It was a modest role, but in any case, so I was in private practice, but I was still in the public law area principally, and but I was operating as an advisor. I wasn't an official. I wasn't a decision maker, but with some pretty senior people, and on a number of occasions, Mr. Crosby, John Crosby, I helped out Mr. Crosby when he'd asked me to come in on a file, and then Mr. Tobin. So I fought under both flags and was comfortable. Yeah, and then let's see, I guess it was 1996. Mr. Tobin left federal politics, returned to Newfoundland, won the leadership of the Liberal Party when Clyde Wells retired, became Premier, and to my great surprise, but he asked me to come in as the head of the public service. And so I took about a 50% pay cut, more or less, and went home and had a wonderful time, working for him in a highly responsible position. And again, Andrew, the clerks, shall we say, well placed, right? You sit in the cabinet room, you advise the Premier. You don't decide. It's the people who are elected who decide. That's very important. But, being an advisor means you're in the game. You have an important role. And then I went to the bench.
Stewart McKelvey is one of Canada's 20 largest law firms, providing a full suite of legal services to clients nationally and internationally, with more than 260 lawyers specializing in core business needs and specialized areas of law. They support public and private sector clients operating across multiple and key industries and sectors, such as labor and employment, defense, technology, energy, and infrastructure. For over 35 years, Stewart McKelvey has worked alongside leading organizations, institutions, regional, and multinational corporations to build their businesses at home and abroad. They have earned a reputation for excellence that continues to grow, and their clients trust them to guide them in matters where experience, discretion, and a deep bench are essential.
It's funny. It's funny, Justice. Many people in this province don't realize, we know who the politicians are, but the clerks of the council are often the people that many people couldn't pick them out in the grocery store, but my God, they carry a lot of weight and contribute to a lot of the decisions, policy, you name it. It's an extremely important role. And I've been lucky enough to realize that. I have to ask about this, and then again, I could go all day. Same with Alex. I'll stop after this, AB. I mean, you're talking about, now you get to be a part of these extremely important decisions, but you were part of a lot of important decisions back then as well. And one that always I think about, I would have been in high school at the time, and many people now may not have their recollection, younger people, but the denominational school change was a huge change in how our province operated in the school systems and education. Maybe some sort of recollections of that. I mean, I'm glad I wasn't a politician during that time, because just having read the Hansards, you could see, the debates and how difficult it was along religious lines and whatnot. But maybe your thoughts, again, having been around during that time and seeing how it evolved.
Yeah. Another person, by the way, who was quite deeply involved was Debbie Fry, who's now the Chief Justice of Newfoundland. But because she was the Deputy Minister of Education, and she played a very important role. But I guess I can give you a couple of little vignettes, maybe breach of confidence or two. But what was really happening was, I guess, a couple of things. The birth rate had gone down. And so there were fewer children in school, right? And so you had all these schools half full of kids, and which didn't make any sense. And the government was in extremely difficult financial circumstances because, of course, it was the moratorium, which was enormously disruptive in people's lives, but also had a huge impact on the government's fiscal position. And so we couldn't afford to have all those schools half full anymore. It just didn't make any sense. And so there was an effort to consolidate the system. And Mr. Grimes, Roger Grimes, later Premier Grimes, he was the Minister of the Education, made very good faith and extensive efforts to negotiate with what we call the denominational education committees to try to come to an agreement as to the consolidation of schools. We weren't getting the results that we needed. It just wasn't happening. And so there was a great deal of frustration, and the government felt that it was at an impasse. And I was in the Premier's office one day. I usually met with him between 9 and 10 in the morning every weekday. And usually Jerry Levine, who was the Chief of Staff, Jerry was always there. For some reason, he wasn't there that day. It was just Mr. Tobin and me. And he said to me, Mac, we got to resolve this. We have to achieve these efficiencies. We can't afford it anymore, and it doesn't make any sense. And the kind of attitudes that Newfoundlanders had, it kind of kept people separate from one another. Those attitudes, they're gone, right? Very large measure, they're gone. And it's a good thing. Those sort of divisions in Newfoundland society are behind us. And he said, so it's time to make a break with that. And so he said, we're going to have a referendum. And I sat back in my chair and I said, sir, I understand, but you'd be betting the government. And he said, well, that's what we're going to do. And then I can't remember, it was a Tuesday or Wednesday. when we had that very brief conversation. And he walked into cabinet and he told cabinet. So there you go. There's my great indiscretion.
Wow. I think you'll be forgiven.
And I can tell you, there was this stunned silence. And then there was, he had understood the mood of the public. He'd understood the mood of his government. I'm sure he had a similar conversation in caucus. He would have had to have it very quickly. And he just understood it was the right moment. And he proceeded with confidence, and he laid the cards on the table, and they had the referendum, and I don't know, it was like 75, 78% or something in favor. And the matter was settled, and the government was then able to make the consolidations that made sense for good education in Newfoundland, right?
Excellent.
Yeah, it was. I was in junior high school, and it was a formative time in my life. You struggle to think of where this province would be today had we not done that. Yeah. Recalling this part of your history, you worked under a Liberal government. You were appointed by a Liberal prime minister, but I have never seen a suggestion in public of any kind of partisanship in your judicial career ever. In fact, you're often described in some quarters as one of the more conservative justices. And I'll explain for the audience that doesn't mean conservative in a left and right way that we think about party politics. We can, in fact, come back to that judicial style in a little bit. But I'll ask what it is about the Canadian judiciary and the Supreme Court that in a country so influenced by America, which has a political dysfunction in its courts, how we maintain that separation and trust that our judiciary remains relatively free from political influence or undue political influence.
Well, we haven't had any history of it. It's not in our political culture. And it's political culture, which is really the most important consideration here. It's just, we have seen the role of the judiciary in a much more traditional way. The idea that you'd have a partisan judge, like you'd have a conservative judge in the big C conservative or a liberal judge in the big L sense, people would say, well, that's not what judges are supposed to be like. They're supposed to, people who've been active politicians can go to the bench. There's nothing wrong with that. Clyde Wells was Chief Justice in Newfoundland. Bill Marshall, one of the high Tories in Newfoundland, sat on the same court as Clyde Wells. And that was fine because they left it behind. They understood that the role of a partisan politician had to be left behind when you went to the bench and you became an independent adjudicator. And it's not, it just feels natural because it's part of our political culture. I would say what has happened in the United States is that there's a couple of things. One is that the society has become deeply polarized. And the second thing is that the courts for a very long time, have been engaged in big public policy issues, such that it is politicians in the United States have come to the conclusion that if they want to move forward their political agenda, they have to have people on the courts who share their views, or the courts will block their agenda. Now, that's a problem, right? Because the court shouldn't be in the business of blocking or advancing anybody's political agenda, right? That's a problem. But if you put together polarization, whereby the common ground in which people in a democratic society come together for sort of reasonable accommodation, for a thorough discussion of issues. Yes, you could vote Republican, you could vote Democrat, but in the end, you accept that the other side are good citizens as well. They're persons of goodwill. They just happen to have a different view from yours. That's collapsed in the United States. And the other team is comprised of people who are sort of have bad motives, and you don't really need to listen to them. And if you listen to them, it's a bad idea. Well, that's polarization, and that's really sort of poisonous towards liberal democracy. Put that together with the idea that you can't move forward your agenda, your political agenda, unless you've got people on the bench, particularly the Supreme Court of the United States, who sort of share your views. Now you have a perfect recipe for the politicization of the courts. And we're not immune from that. If we will fall into the same trap, if our society becomes as deeply polarized as it is in the United States, and it is not. Our society is not polarized in the same way. And if it does become polarized, we will suffer for it. Our liberal democracy will not function the way it should. And similarly, if somehow it becomes understood by politicians that to advance their political agenda, they've got to have people on the court who think the same way they do, they're going to appoint people accordingly. And so those two things in the United States, which have led to the politicization of the courts, have not been present in Canada. And thus we have not fallen into the same pattern and with the same problems. But if we allow ourselves to become polarized, if we are not diligent citizens in terms of listening carefully to the views of our fellow citizens and seeking to accommodate them and considering them as persons of goodwill with whom we share values as opposed to pulling away from one another, we could end up there in time. And that would be a great loss.
I'm glad you said that we aren't immune from this, because I would argue that this country has become more polarized, certainly nowhere close to the extreme that we see in the United States, but in recent years. And since the onset of the charter, major public policy decisions are decided in the court more and more. The Harper government saw a large part of its agenda, particularly around criminal justice, stymied. Yet this issue that we see in the U.S. doesn't happen here. Now our parliament gets things done in a way that the U.S. Congress doesn't. So perhaps that's part of it. And I suppose this underlying cultural resilience is the other piece of it. But would you say that there is a risk there nonetheless?
Well, what I would say is that two things. One is that I am concerned that far too often Canadians define themselves by reference to the United States. Right? I don't watch American television. I just don't do it. Number of people I know faithfully read the New York Times. I don't. I read The Economist, which is an English sort of comparable publication. I refuse to define myself by reference to what's happening in the United States. I have no interest in it. And I think it's unwise. And it's, in a sense, it's sort of giving up on your own country. But I think that to the extent that Canadians, both sides of this political spectrum, right, particularly out towards the ends of the political spectrum, define themselves more and more by issues and the cleavages in the United States, guess what? We start to become more like them. And then we suffer the same problems they have. So that's the first point. The second point is, I've always been, people have said I'm conservative. I use another word, cautious. Maybe cautious, traditional, moderate. And so I'm cautious in terms of the courts not taking on a role which is properly carried out by those who are elected, those who have a mandate from the electorate. And I have a lot of confidence in my fellow citizens. I think they're pretty sensible, moderate people of goodwill. One of the greatest thing about liberal democracy is we have the means to reflect and say, well, I'm not sure the direction we're going in is the right one. And then we have the means to change the direction. We say, well, Government A has had an opportunity to carry forward their agenda. They, demonstrated a degree of leadership, but there's a certain amount of disappointment. We want to give, B, the B crowd, sort of, as opposed to the A crowd, an opportunity. So you can course correct through the democratic system. The courts don't operate like that. Our decisions are sort of ex cathedra, from the chair. We speak from authority. And particularly when we speak on the Constitution, there's nowhere else to go. I mean, you can say, well, you can amend the Constitution. That's not practical. So I take a very cautious approach as to what it is that the courts should decide and what it is that those who are elected decide. And yes, there is a little bit of space between me and some of my colleagues in terms of, the role of the courts. But that said, the Charter represents a manifestation and a choice by Canadians that certain principles, certain interests are to be protected. And if the elected representatives of the people infringe upon that, then those who've been adversely affected can come to court and receive a remedy. So I don't see any contradiction between the two, but I do have a certain cautious approach as to the courts not always taking an ever-increasing role, extending our decision-making deeper and deeper into matters of public policy that, from my own experience, governments are far more capable of evaluating, and the democratic system has built into it these sort of self-correcting mechanisms that, in a way, don't operate as well, or even at all, in the judicial system. If you don't like my decision, I'm afraid you're out of luck. So to speak.
I've got one more follow to that, and I apologize, Andrew, and I'll cede the mic back.
It's all good.
I really appreciate that description of cautious, where some might say conservative, and you gave a really eloquent description of the role of the court and referred to the Charter. Many of your written decisions, I think the public often thinks of the Charter primarily when they think of the Supreme Court, but separation of powers still crucial. A matter in which where you describe a little separation from your colleagues. You sometimes seem to be more cautious on the question of provincial autonomy.
Yes.
The Churchill Clause decision certainly was one of those, not an over-reliance on the supremacy clause. Is that in any way influenced by being a Newfoundlander, by being raised in a province on the periphery of Canada that has stubbornly kind of clinged to autonomy?
Well, it has to be, and it is. If you come from Ontario, especially if you come from Toronto, you have enough political influence, you and the people around you. You don't have to worry about the relationship between the federal and provincial governments, because no one is going to disregard your views. It's a numbers game. How many seats are in the GTA? Every single government, conservative, liberal, at some point there's an NDP government, they're going to have to take into account the concerns of people in the major urban areas. I use Toronto as an example, Montreal, Vancouver, whatever, just because it's a function of representation and presence in the legislature, which then feeds into cabinet decision making, etc. Newfoundland has 7 seats. Okay, it doesn't decide what the government is. And we've been very fortunate in terms of having, over the years, a number of very strong ministers. And I give you an example, reaching back a ways, Don Jameson. Don Jameson, who happened to be a Liberal, was an enormously influential individual, but not because he was from Newfoundland. It was because he was Don Jameson, a man of very considerable ability. But to come back to the sort of the point that if the division of powers between the federal government and the provinces really is shifted heavily towards the federal government, the ability of Newfoundlanders or Nova Scotians or Prince Edward Islanders or the people of New Brunswick or other smaller provinces, you might say, like, I don't know, Saskatchewan's got 1 million people, whatever, something like that, versus the big provinces, 15 million, 16 million in Ontario, 5 or 6 million at least in the GTA, or Greater Toronto Area. I mean, if we don't have meaningful authority under the division of powers, we become an administrative unit in which we have lost any meaningful control over our own affairs and our future. That's not the deal. My father voted twice in 1948, and he voted first time for responsible government, but the second time he voted for Confederation. He didn't vote to become part of a country in which Newfoundland would just be unable to have a meaningful say in its own future. He understood that when we joined Canada, we would be able to maintain a certain wholeness in terms of our own place in the society, the Canadian society. Now, that's partly a matter of culture. It's partly a matter of how we live our lives, but it's partly also about the authority of the House of Assembly and the government of Newfoundland and Labrador to make decisions that matter for us. And it's the same for all of the provinces. There's an enormous sensitivity in Quebec about it, for historical reasons and for reasons of language and culture, etc. But coming from a smaller province, I'm acutely aware of this. And I ain't going to forget it.
Really appreciate that. Justice, we're getting ready to conclude. I can't believe we've been good enough to grant us this much time. But before I go, just a couple of things. Number one, I've probably heard more talk in the last year of the notwithstanding clause than I heard at any point while I was the Attorney General in Newfoundland and Labrador. It was for a long time it wasn't mentioned. It seems like it's being mentioned an awful lot in various provinces. I don't know if you're allowed to comment on that or not, but I just bring that up to see if there's any thoughts on that, because it seems like it's coming up an awful lot when it comes to the provinces trying to move themselves forward.
So in the third week of March, we have 5 days of hearings on essentially on the notwithstanding clause. So you will understand why I can't really say much about it.
Well, I think you just nailed it there by saying that you have 5 days coming up. That's perfect. I wasn't sure if I was going to get there, but I'm glad I brought it up. The second thing, my second last thing, not everybody understands, I'm talking about the listeners, the pillars of democracy. And, not everybody is lucky enough to be involved in any. And in your case, I would consider you as someone who has been involved with all three. I mean, sitting on the judiciary, being a part of the executive. And while you were not a legislator, you certainly had an intimate knowledge of the legislature. Do you feel that having that sort of multifaceted experience has contributed to your role, what you're able to do as a justice on these different levels of court? Do you think it's helped you?
It has. I mean, it was less important when I was a trial judge. We didn't deal with the kind of issues I do deal with here. It didn't come up that often. It wasn't really relevant that often when I was on the Court of Appeal. And it isn't relevant in every case here. I mean, if you're talking about something, breathalyzer under the criminal code, right? It's not particularly relevant to that. But it's surprising to me. I have found it interesting, maybe, how often the perspectives that I gained from my modest participation in the legislature, my fairly extensive participation in the executive, and of course now I've been on the bench for a while, and even the international stuff. I mean, my 6 months down at the UN General Assembly, long time ago, and then, oh boy, I mean, there were three major files in which I was involved with UN agencies, New York and Geneva and Rome. It was kind of good work if you can get it. Working on it, and the international perspective gives you just kind of a more global, no pun intended, view of things. And yes, it does inform how I approach issues, and also working at the federal level and the provincial level, because it's not common actually to do it. So I've got more perspectives, I guess, than anybody else in the court, and I think I have profited by it, and I do bring it to bear, and it does inform how I approach issues.
Excellent.
I've got just a couple of lighter ones before I'll pass it off to Andrew and we'll conclude. And I'll briefly say for the audience that I said separation of powers earlier when I very much meant division of powers. So I'll resist the urge to put my head through the wall. And the other one, just kind of a question, maybe one you've gotten before, in your time on the court, is there a particular decision in which you had, perhaps you were writing for the majority, but even in your argument with your fellow justices, in which you felt you had a very decisive role, and presumably a major decision that stands out for you the most? I guess another way to phrase that would be a favorite decision.
Favorite decision happens to be a dissent.
What a surprise.
And it was a case called Power. And it had to do with parliamentary privilege. And it was really it was about the interaction between the Charter and the internal operation of legislative institutions. And my view was that you really had to maintain a very strong separation between the operation of the Charter and the internal operation of legislative institutions, because otherwise the courts would intrude into the operation of legislatures. And that is profoundly problematic. Once the legislature has decided, it's open to the courts to review the decision taken by the legislature for its conformity with the Constitution. But the courts must never reach into the internal operation of the legislatures. That is a world unto itself. It makes its own rules, it controls its own operations, and in the end it answers to the public through elections and the like. And I opened the reasons for decision with a quotation in Latin, which I won't render to you, from Cicero. And the translation is, "Preserve, I beseech you, those liberties that your ancestors have given to you as an inheritance." And so you see, I sort of get a bit more of a traditional, more cautious role. That the Charter did not make of Canada a free and democratic society. We were a free and democratic society, and we continue to be. But some of the elements that make us a free and democratic society were given additional protection through the Charter. So I guess what I was saying is liberal democracy is protected by the Charter, but there are some components of liberal democracy which, in a sense, are even beyond the reach of the Charter. And one of those is the internal operation of the legislature, which is a place in which what dominates is the mandate accorded by the people to their representatives, and the autonomy of that institution to conduct its own affairs without the courts reaching into it. That may sound a bit obscure. I think Andrew may kind of grasp it a bit more readily because you've been there. But that one to me was perhaps the most fundamental decision I've had a role in preparing. Yeah.
Justice, this has been fantastic. I think this is how I want to end this today. I was lucky enough, as you know, and as Alex knows, I was, I was in politics for about 14 years, 10 of those in government, about 5 of those sitting as the Attorney General. And I was always lucky that I was always blessed that I had a great working relationship with our Court of Appeal and our trial division, with all the members. It certainly was helpful when you're trying to make decisions to be able to talk to people. But of all those years and of all those moments and everything else, I will say that if it's not the top memory, it has to be up there. Maybe along with maybe the first time you get elected. But being in the Supreme Court of Canada that day when you're sworn in, alongside of the federal minister, a room full of Newfoundlanders and Labradorians, all your colleagues on the Supreme Court of Canada, and by virtue of being the Attorney General, I got to be there and speak. It's still a moment. It was not that long ago, actually, that my he's a practicing lawyer now. He was my assistant at the time, John Sams, and we were both there that day, and we were just sort of reflecting on it. And I just want to say to you, I remain as proud today as I was then about the fact that I got to be there, and that was because of you. You were and remain the only Newfoundlander and Labradorian ever to grace the court on behalf of our province. I only got to be in that court by virtue of getting to speak to thank you and thank the court. And so it's just a chance for me to sort of, again, thank you. I mean, you've had so much public service over the years. You've done so much for this province, for this country. And for me personally, getting to be there on that special day is a moment I'll never, ever forget. And it was only because, thank God, you spoke French, number one. But number two, thank God that you had the ability and the experiences and the intellect and the work ethic that you had that made you such a fitting pick for the Supreme Court. And here you are 10 years later, we're getting to talk, and you're still proudly flying the Terra Nova flag. Just a chance to say thank you, not only for that, for your service, and for taking the time, as Alex said, to be here with us today.
Well, I have to say that you were a very hard act to follow. You blew the doors off that day. Everybody was so impressed by your speech. But,
well, I'm good enough to give credit where it's due. There was a young man who we spent a lot of time, Mr. Sams and I spent a lot of time on that, and it was absolutely the most important speech I probably ever made. It was certainly the most fun, certainly the most memorable. And but on that note, Justice, look, it's great just to see you and chat with you as always. And for sitting here and taking the time to do this, we're really, really super appreciative, sir.
This is a real privilege. Thank you.
It's been a pleasure to do it.
All the best, sir. Take care, and we will hopefully get to talk to you again soon.
Okay, thanks. Bye-bye now.
Stewart McKelvey is one of Canada's 20 largest law firms, providing a full suite of legal services to clients nationally and internationally, with more than 260 lawyers specializing in core business needs and specialized areas of law. They support public and private sector clients operating across multiple and key industries and sectors, such as labor and employment, defense, technology, energy, and infrastructure. For over 35 years, Stewart McKelvey has worked alongside leading organizations, institutions, regional, and multinational corporations to build their businesses at home and abroad. They have earned a reputation for excellence that continues to grow, and their clients trust them to guide them in matters where experience, discretion, and a deep bench are essential.
Wow, Malcolm Rowe. When you told me that he was going to come on as a guest, I was taken aback. Supreme Court justices don't do media appearances very often. Just what a privilege, what a mind having him on here. one of the highlights, maybe the highlight of this show for me to date so far.
He is someone that, he's a Newfoundlander and Labradorian, true and true. Like he even there, and I hope people will check out the YouTube, the flag that he had flying in his office in Ottawa. You can see it on the YouTube slides, the old Terra Nova Dominion flag. Um, but again, yeah, for him to do that today, I know he speaks at a lot of law schools, legal functions, but someone like that's not usually taking the time that he took with us. And thankfully, though, you always sort of downplay your legal background, but you're asking way more sophisticated questions than I am. That's for sure.
Well, it reminded me, I joke with you sometimes about how we're both fake lawyers. I forget you were the attorney general for 5 years. You're a Queen's Counsel, I think.
I
King's
always
Counsel.
joke that I was that I was there because they literally had no one else to put in that position. It was just me or nobody. But as I said in the interview, AB, that day when he was sworn in, sitting in the Supreme Court of Canada, surrounded by former premiers, cabinet ministers, tons of Newfoundlanders and Labradorians, it was like live streaming back home and getting to sort of speak on behalf of the province. I mean, Seamus O'Regan was there. John Sams and I were there. John was my assistant at the time. And again, credit, he was often the brains of the operation. There's no doubt. But it was such a moment of pride. But again, this is someone who had a lot of people sort of in his corner because he had worked with so many people. I mean, he had worked with premiers and prime ministers, cabinet ministers, his colleagues. The big hubbub, I'll never forget. So Justice Cromwell left. And so myself and John and the department talked about what are we going to do here? Because that sort of cry had been heard from Newfoundland and Labrador before, but, we should have someone on the bench. And I remember actually a previous minister had written, it didn't pan out. And we decided, we're going to actually write a letter to the prime minister and say that now is our time, not because we're due, but because we have the people, we have the minds here. And there's some risk to that because if you write it and it doesn't go anywhere, it can be sort of, you can take a bit of flack for that. So there was a little bit of risk in doing that. We did it anyway. But the big scary factor at the time was that he was also the first justice to be appointed to the Court of Appeal where French was, being bilingual, was mandatory. And so a lot of our great legal minds, I don't think could have passed that mandate. It was just too late in their career. And we didn't realize that Malcolm was bilingual. And thankfully, I mean, when we knew that, it was just all perfect. But again, just goes to speak to the guy. He, again, a brilliant man, but also a practical man. And again, I'm still a little blown away that he took the time here with me and you today. It was pretty cool.
What I loved was, I asked him about being a champion for provincial autonomy, and he is one or two of the judges who are most likely to invoke and protect the rights of the provinces in that division of powers and that kind of eternal struggle with Ottawa. Whether or not being a Newfoundlander affected that, he didn't hesitate. He didn't prevaricate. He just said yes. And for our audience, which is broken up between Apple and Spotify and YouTube, the YouTube audience is seeing this Dominion of Newfoundland flag behind him, which he probably spent 5 minutes pre-taping, making sure it was positioned so nobody would miss it, because he's very proud of that. And
Absolutely.
Something we really appreciated.
Absolutely. No, it's funny. I'm glad you mentioned that because he did. He was like, this flag needs to be seen. And it was, again, just really have a lot of time for that gentleman, and it's someone we should all be proud of. On that note, AB, speaking of YouTube and the streams, listen, folks, please tune in, continue to do so. We're so pleased at the commentary we're receiving and the feedback. We're going to keep at this. We got more people coming. We're so lucky to have great guests, and hopefully you guys are still enjoying. So check out the streams, leave a comment on the different YouTube, this, that, whatever, Honourable The Hack at Gmail. Toss something at us and let us know how you feel. But AB, I'm already looking forward to the next one, brother. So on that note, onwards and upwards.
Till next time. Bye.